Court practice this evening and the rest of this week. I am hoping that all of you have the required notes for Magistrates Court practice and that you have gone through those notes. It will stand you in good stead if you have done so, because it will make it easier for you to understand what we are going to be dealing with throughout this week. Just a few house rules so that we can have a smooth process throughout this week. Let us try to limit our questions to the subject at hand, namely Magistrates Court practice, and more particularly civil litigation. That way we will be able to get through what we need to get through by the end of this week. I hope to be able to impart some practical knowledge to you with regards to the subject at hand. Now, we all did our university degrees before we signed up for this course, more particularly the training course with the LSSA. And there we will have, at university, of course, dealt with the theoretical aspects of Magistrates Court practice, amongst other things. Here I am going to try and make your experience as practical as possible from a perspective of someone who has practiced not for a very long time. I was admitted as an attorney in 1999. So I think I have just a little bit of knowledge to be able to impart something to you by the end of this week. Right, now kicking off, I'm going to be touching on a number of ethical rules as we go along. I am obliged to do so because it's very important that we remind ourselves that we are in an honorable profession and that we need to do what is right at all times. We're going to kick off with what your relationship is between you as an attorney as well as your client. You must remember that as an attorney in private practice, you will be self-employed, you will be working for yourself, and at all times, you will be selling your time to your clients. It's therefore important that when you engage with your clients, you treat them with the utmost respect and you give your clients your time at all, the best of your time at all times, and the best of your attention when you give them your time. After all, when your client is happy, your client will want to pay you at the end of you having performed your mandate. So therefore, always treat your client with the highest of respect whenever you engage with your client, be it in person or be it telephonically or be it in correspondence. Try to keep it professional at all times. You will be required to consult with your client, to take instructions from your client. And when you do so, always do it in a professional manner. Now, when you have that first consultation with your client, you will need to take proper and full instructions from your client as to what your mandate is that you need to perform on behalf of your client. And at that first consultation, it is crucial that you get as much as possible, if not all the information that you will require, as well as the supporting documentation to be able to perform your mandate. Take careful notes of everything that takes place during your consultation. because it will be important for you to remember exactly everything that your client tells you or expects from you when you perform your mandate on behalf of your client. And as I said, you should always treat your client with the utmost respect. Avoid any distractions during your consultation with your client. Put your cell phone away if you have to, or give it to your secretary to keep during the consultation. There is nothing as distracting to a client or disrespectful towards a client than an attorney consulting with that client, and yet the attorney is on his or her cell phone most of the time, responding to WhatsApp messages or looking at your phone. That is totally disrespectful towards your client unless it has something to do with your consultation. So avoid any distractions at all times so that you can give your client your full attention. And when you consult with your client, make sure that okay, thank you for the music, but please don't let it happen again. It's distracting. I would like to ask everyone, please, to ensure that their mics are on mute and that we are not distracted unnecessarily, such as just happened now. Right. When your client is telling you their story, you must remember that it is your client's story, not yours. It is not your story. Let your client tell his or her story themselves. This is the part where the skill of listening comes in. And it's very important and critical for you to represent your client, because the mere absence or inclusion of a simple word such as not could have the complete opposite of what it is your client is trying to tell you. So make sure that you listen very carefully when your client gives you the facts in terms of your instructions. As I said, do not finish your client's sentences for them. Do not fashion their version into what it is you want to hear. Let your client tell their story to you uninterruptedly. It is only after you have heard all those facts from your client that you yourself, as the attorney, will have to now distill from those facts which facts are relevant and which facts are not relevant. And that will determine what your course of action is going to be. Your client will not at all times come to you with a clear instruction as to what it is they will want you to do. And can you please mute your mic? Mtunzi, is it Mtunzi? Colleagues, come on, this is very distracting now. It's disrespectful, but very distracting. I'm going to, for the last time, please ask that we all mute our mics. After you have consulted with your client, as I said, you will then have to determine which course of action will be best for your client to follow. And when you have consulted with your client, it is best for you to confirm your instructions from your client in writing. Send a letter to your client confirming your consultation. In the same letter, spell out in clear terms what your instructions are in terms of the consultation that you had with your client. You must also then explain, as you will have done in your consultation, the possible legal consequences that will come from your instructions. Very importantly, you must also, during your consultation, and in writing, of course, confirm the estimated legal costs that your client will be liable to you for and how those payments will be made. You must also then meticulously spell out to your client what the procedures are that you are going to be following in terms of the instructions. And lastly, very importantly also, how will you report to your client on progress in the matter? Will it be written or will it be orally? I suggest that you try by all means to report to your client in writing, because it's not very easy to commit everything to memory. You must remember that as an attorney, you will not be managing one file at a time. You will sometimes have hundreds, if not thousands of files that you will be running at the same time in respect of different matters. It will in that case, become important for you to commit everything to writing so that you can know what is happening in each file. As a rule of thumb, although I'm not a practicing attorney anymore, I'm now an advocate, I used to report to my clients every 30 days. You must have a diary system according to which you work. And in your diary, you will put in on the specific date that you want to see a file, when you want to deal with that file. On the specific date, your secretary or your filing clerk will take that file out of the filing cabinet and bring it to your attention. You will then, because you will have known why you diarized the file, have a look at it, look at its contents, and preferably you will have made a note in your file as to what you should do on that date when you next pull that file from your diary. As a rule of thumb, as I said, I used to do that every 30 days. So even if nothing has happened after 30 days in that file, write a letter of progress to your client. Even if you say nothing has happened in the last 30 days, or the days within which we've expected something to happen has not happened, and once it happens, I will report to you. If not, I will then, after another 30 days, have drawn the file from the diary. I see there's a question from Peladi. Which topic are we on? We are doing magistrates court practice, and we are dealing with administration, the first topic. I hope that answers your question. It's very important that you communicate with your client with regards to progress in their matter. Unless it is an urgent matter, My rule of thumb is normally 30 days, as I said. That is the regularity with which I visit a file. Dolly Engelbrecht, no, there are no slides. We are referring to the Magistrates Court practice notes. I hope that answers your question. Thank you. Clients become agitated when an attorney does not report to them on their matter. And sadly, the Legal Practice Council, and before the Legal Practice Council, it was the Law Society, the various law societies, are inundated with complaints about attorneys not responding or corresponding with their clients. We're on page 24, Rosalind. 24 of the Magistrates Court practice notes. Not responding or not corresponding with your client is considered professional misconduct, because you are obligated to your client and you are obliged to correspond with your client on a regular basis with regards to the progress of their matter. And if an attorney fails to correspond with their client with regards to the progress of their matter, that attorney could find themselves in trouble with the Legal Practice Council. So be careful not to neglect corresponding with your clients, especially with regards to progress of their matter. Coming back to that first consultation, as I said, you should try and get as much information and documentation from your client in order to perform their mandate or carry out their instruction. Be careful not to proceed with an instruction where you have insufficient facts and where you have insufficient documentation. Do not be tempted to proceed to action without sufficient information or documentation. Use that opportunity to ask your client for more documentation and for more information to be able to carry out their mandate. That is the only way in which you can carry out your instructions or your mandate fully. And if needs be, call for a further consultation thereafter, where you will be provided by that client with the information as well as the documentation to properly and fully carry out their instructions. Now, when you've consulted with your client, or when you have decided that this is going to be your client, it is now up to you, the attorney, to open up a file. And this is literally taking a manila folder or any other file that is used to, and onto which you will record your client's details, as well as some other important information. And examples of information that goes on that file are as follows. You will need to get your client's full names. If your client is acting on behalf of a juristic person, such as a company or a close corporation or any other organization, you will need to get the full details of that entity and record those details on the file. If it is a company or any other juristic entity in terms of which that person is acting, you will need to get a written mandate, normally by way of a resolution by the directors of a company, authorizing this person to institute legal proceedings on behalf of that entity. Get, if possible, the registration number and documents relating to that juristic person. Keep them on file. And if the person is acting in their personal capacity, ask them for a copy of their identity document. Ask them for proof of residence. Ask them for their telephone number. Ask them for a next of kin, an alternative contact person. It could be a spouse, a contact number in case you are unable to get hold of them. Ask them for an email address. Record everything on the file so that it is easy to find that information should you need to contact that client for any reason relating to your instructions. In your file then, physically, you will need to create subfiles. One such subfile will probably be correspondence, where you will file every email, every letter that is written between yourself and the client. It's important that you keep record of everything on the file. Yes, we are trying to go paperless and we are trying to keep everything online these days, but you will find that electronic or digital systems fail and they collapse, and then you will be left wanting with regards to access to your documents. I am still old school and I still believe in keeping physical documents on file. We also have our beloved ESCOM who switch off our electricity at times and we do not have access to those things. So there is a good example or a reason for you to keep hard copies of everything on your file. Of course, it will only be the essential documents. Whatever you deem not essential at that point in time, you may keep on your computer or printing when the time is right. You will not always need every piece of documentation at the time, but it is helpful to have it on file when you need to have it. When you consult with your client, or when you make a telephone call to your client or receive a telephone call, it is advisable to always make meticulous notes of those consultations and those telephone calls. As detailed as possible. Make notes of those consultations and telephone calls. Who is the person that you spoke to? What time did you speak to the person? What was the nature of the conversation? What did you say to each other? What did you resolve to do? And after you've had a telephone call or a consultation with your client, always follow it up with a confirmation in writing via email or letter or whatever communication you use with that client. And it will also stand you in good stead if you follow up everything in writing for one day when you have to respond to, hopefully not, a complaint by the Legal Practice Council. Then you have everything on record. I have to warn you of the pitfalls of not communicating with your client, as I have done previously. And I believe some people have joined a bit late too. You will always be at risk of being reported by a client to the Legal Practice Council, who we all know is the custodian of the ethics and rules of practice for attorneys. So you always, when you perform in terms of your mandate, always make sure that you cover yourself in terms of meeting your obligations by having copies of every piece of correspondence between yourself and that client. And when your mandate is completed, you still are under an obligation to those records. The legislation requires you to keep for up to a maximum of 5 years a file of a client together with its contents after you have completed the mandate. It's not burdensome. It may be so if you have voluminous files, but it will only protect you in times when you need to explain yourself, when there is a complaint about anything that you have done. So keep your correspondence, keep your file notes on your telephone calls in chronological order so that you have access to them easily in your file. You need to also, when you start practicing, have designed a letterhead that is neat and represents your firm and what it stands for. Remember, your letterhead, like your receptionist, is the face of your firm, and it must be attractive and pleasing to your clients. When I say attractive, I don't mean it in the sense that you are probably thinking now. It must be soft on the eye, it must be professional, and it must not be offensive in any way. So consult, if you have to, an expert or a professional in that field to design a letterhead for you that will contain all your necessary information. Avoid writing meaningless letters to your clients. Every letter or email that you write to your clients must have a purpose in mind. Remember, when you bill your client for all of these letters and emails, you must be able to justify it in each case. You cannot simply decide that because you do not have any files in front of you today, you're just going to pull out the first 10 files that come to mind and write everyone an email saying, "Hi, how are you? Did you survive COVID?" No, that doesn't work like that. You must have a reason why and a purpose for writing correspondence. Normally, something will have happened in your client's matter, or something will have not happened, as I said earlier on. Even if nothing has happened in the matter, make it a habit to every 30 days. It's an example only. I use 30. You may use different time frames, but decide in each matter what is a reasonable time frames within which to tell your client if something has happened, if something has not happened, and if something is about to happen. But your client will feel important if they get a letter from you regularly updating them on their matter. And again, when you write to your client, keep it professional at all times. Keep it professional. Write in a plain manner in which your client will understand what it is you are trying to say. And I'm going to digress a bit here. In legal opinion writing, as well as legal writing, we emphasize that we must try to use simple language when we communicate with our clients. And knowing who your client is will help you to decide at which level to pitch your communication. But by all means, try to keep it as simple as possible so that communication is flawless between you and your client. Avoid writing long letters. Keep it as simple as possible and as short as possible and to the point. There will come a time when you will want to use the term "without prejudice to our client's rights." This is normally done in communication between the attorney and the attorney for the opposite side. And the words "without prejudice" are used when you do not want the contents of that letter or correspondence to be disclosed to the court in any litigation that is to take place. So that letter will be inadmissible if it contains a settlement offer or a compromise in the litigation that is pending before the court. You need to familiarize yourself with the case of Naidu versus Marine and Trade Insurance, which was an appellate division case, and it's reported under the 1978 Volume 3 SA Law Reports, page 666. As I said, it's from the appellate division as it was then. It's important that you familiarize yourself with that case and the principle there, which dealt mainly with without prejudice correspondence. Right. I see that we are making some notes here on the chat, and some of them have been answered. If you have any questions, please feel free to write them there. But as I said before, try to keep it to the topics at hand and to magistrates' court practice civil litigation. I will make time in between to address any questions. Apelele, go to page 25 of your notes. That is where you will find that the citation for that judgment of Naidu versus Marine and Trade Insurance. Page 25 of your magistrates' court practice notes. The issue of fees between you and your client is most probably the most important issue, other than your client's instructions, of course. And I say this because if you do not address the issue of fees up front at your first consultation, there is bound to be misunderstanding between you and your client about payments. And you will normally see that when you send out your first invoice to your client. Then you will have this heated inquiry from your client. But why is this so much? Why did this take so long? You did not discuss this with me. So in order to avoid all of that, rather in the beginning, set out clearly the terms and conditions, the rate you will be charging, and in terms of what you will be charging that rate. The Legal Practice Council provides a guideline for attorneys to charge fees in respect of certain matters. Nomhle would like to see my face, okay? So it is easier to follow. Is anyone else experiencing difficulty following me because my video is not on?
Yes.
Okay, then just say you want to see my face.
I think it's the ladies that want to see your face.
I beg your pardon?
I think it's the ladies that would like to see your face.
Okay, there is my face if you would like to see my face. Right.
Yeah, you should just keep it that way in order to keep our focus.
To keep your focus.
Yes.
Okay. All right. Right. Let's focus then. Okay, I've told you about this decision on page 25 in Naidu versus Marine and Trade Insurance. During your own time, please read that judgment. I will also be referring you, and you will see in your notes there are numerous references to case law. We are not going to deal with each and every case during this session. It is up to you to go and read during your own time those cases and their relevance. Someone's complaining that the video affects the bandwidth. All right, so I'm going to switch off the video again. As soon as somebody else wants to see my face, then I will show it, all right? There's a complaint that the video affects the bandwidth, so I've switched off the video again. I was talking about fees. It's very important that you set out the criteria regarding fees so that there's no misunderstanding from the very first consultation. As and when you do any work on your client's matter, debit a fee immediately when the work is done. Many attorneys do not follow this rule because they agree with their clients that they will charge them at the end of the matter. A matter could take anything from 6 months to 6 years to finalize. Are you going to remember every single attendance that you've done in that file during those 6 months, those 6 years? That is where taking down meticulous notes on every attendance comes in good stead. You will then be able to, when you do your invoice at the end of the matter, be able to carefully extract from your file notes, from the correspondence, each and every attendance that you've done, going through your pleadings, going through your notices, going through all the reports that are contained and all the other documents that are contained in your file. You will be able to then draw up an extensive and complete invoice for your client with regards to all of the work that you have done. So it's important for you to debit your fees as and when you do the work, because at the end of the matter, you will not remember everything. So debit your fees, even though you are going to be paid at the end of the matter, but debit your fees on a regular basis as and when you do the work. You must remember, as an attorney, you are selling time. And every time you open a file or you look at a file, you peruse any document in there, that is work. That is time that you are spending on that file, and you are entitled to be paid for that. So make meticulous notes on every attendance in the file. Now, you will also know that firms that are registered these days also have to be registered as Pty Ltd companies. And when you do that, after a certain threshold, which I believe is 1 million rand, you have to register for VAT. You will have to register for VAT with SARS, the South African Revenue Service. And when you do register for VAT, you are entitled to charge 15% on top of every fee that you charge a client. But obviously you have to pay that money over to SARS. And if you immediately debit your fees, there are VAT implications. And if your account is not paid within 60 days, your firm is liable for the VAT on those fees. Even though they are unpaid, you still have to pay fees on those, sorry, you have to pay VAT on those fees. So you have to make sure that your client pays you on time, preferably within 60 days. And if your client has not paid you within 60 days, make it clear to them at that very first consultation already that if they do not pay your fees within 60 days, no further work will be done on their file until you have been paid in full. And this is not something which you hear or you will read in the books, but you will have clients who do not pay you. You will have clients who disappear on you, and you have to find them. And unfortunately, You will have to also sue your own clients for your fees. Hopefully that will not happen. But when it does happen, you will need to know what to do. And that is why it is so important for you to have on that file all the details for your client. Their full names, their ID numbers, copies of their ID, proof of residence, everything that you may need. Although when you do ask for the information at first, it's not to sue your client. It's just so that you have sufficient information on hand to be able to justify acting on behalf of your client. But secondarily, that information will come in good stead to you when you need to find your own client in order to convince them to pay you for the work that you've done. Now, the Legal Practice Council sets out the duties of a legal practitioner. And these are as follows, and you'll find them on page 27. I will go through each one individually because I feel they are all important. The first one is to be a competent legal practitioner. What is a competent legal practitioner? One who is able to advise his client and assist his client in a competent manner. And of course, in order to be a competent practitioner, you must have the thorough knowledge of the substantive and procedural law. Without those two, or without any one of those two, you will not be a competent legal practitioner. You must constantly be willing to research the law in relation to your client's problems in order to find a solution to their problem, if any. You must be honest towards your client. You must be honest towards your opponents, and you must be honest to the court at all times. You must never, ever be part of any form of fraud or dishonesty, despite your client's wishes. Know when your client is asking you to do the wrong thing. Do not be tempted by money in any amount to do the wrong thing. And if you have to ask yourself, am I doing the right thing? You are probably not doing the right thing. And that is the criteria which I used when I was practicing as an attorney. Even now as an advocate, I ask myself the question, am I doubtful about this? And the moment I doubt it, without even being sure if it's the right thing or not, I know that it's the wrong thing. The mere fact that I doubted whether I should do something or not is already a red flag for me not to do something. You are also under a duty as a legal practitioner to act in accordance with your client's instructions at all times. Be mindful, though, that your client does not always have the right to dictate the manner in which the service may be rendered by you. You are there to guide your client as well, to tell your client, no, I cannot do this. The law does not allow me to do this. I therefore cannot do this. If you want me to do this, it is unlawful and I will get into trouble with you and we may both go to jail. So I'm not going to do this in this way. I'm going to do it the proper way. You also, as a legal practitioner, have a duty to report to your client when it may be necessary or when it may be reasonably expected of you. There are two scenarios there, when it may be necessary. Earlier on, I told you, you report to your client when something has happened. This is necessary. And you also report to your client when nothing has happened, when it may reasonably be expected. That is where the 30-day period comes in. I now feel that 30 days have passed. and nothing has happened in my client's matter, I write them a letter. Because it's a reasonable period within which to write to them. Otherwise, they will think I'm not doing anything in their matter. Even though nothing has happened and nothing is necessary, you tell your client that. You also have a duty to conduct a relationship of utmost trust with your client. In other words, at that first consultation in your office, you put your client at ease by telling him or her that whatever they tell you will remain within the four walls of that boardroom or office that you are consulting in, and that you will not especially go home that same night and tell your spouse what your client told you. Yes, attorney-client privilege even stretches that far. Do not take your work home. Do not share with your spouse what your clients tell you. Not even to make conversation at home, but keep your work at work and keep your home business at home. And that goes not just for attorneys' practices, but in all aspects of life. You have a duty to serve your client's interests to the best of your ability. To the best of your ability. That suggests very high levels of concern at all times over your client's interests. You have a duty to always honor your client's right to confidentiality. There again, the example of taking your client's work home with you, sharing it with your family, discussing in the pub. Do not break that relationship of confidentiality at all costs. Your client will not always remain your client. There will come a time when, for whatever reason, your client terminates your mandate. Your client says to you, I no longer want you to represent me in this case. I would like you to please withdraw as my attorney of record in this case. If there is litigation that is ensued by way of pleadings or affidavits, you will, as the attorney of record, have to file a notice of withdrawal as attorney of record. And you will have to serve that notice of withdrawal on your opponent attorneys. You must do so within a reasonable time. And in your notice, you must disclose your client's last known address to the clerk of the court and to all the other parties who are involved in the matter. And as I said, practically, it will be a notice of withdrawal as attorneys of record. You will state there in the notice, take notice that the firm of attorneys representing the plaintiff hereby withdraw as the attorneys of record for the plaintiff. And then you, in the same notice, say, take notice further that the last known address for the plaintiff is as follows, so that the opposition will know where to serve any further documentation on the plaintiff until the plaintiff has found a new set of attorneys of record. Right. I don't know. I'm new to this platform. I don't know how we are going to allow for questions. Are we going to ask questions on the chat, or are we going to raise our hands first and then I'm going to give you an opportunity to ask questions, if any?
Well, in case of need, we will raise our hands. I would prefer that. Thanks.
I didn't see your hand there.
Oh.
Who was that? Ntamulo?
No, Leroke. Leroke.
Leroke. Oh, JL. Okay. Thank you. So you will raise hands and chat. Thank you very much for that.
Thank you, sir.
So in the absence of any hands then, we shall move on to the following. Now, you will see at the end of, we are now on page 28. And this was the first topic that I dealt with. We are now going to move on to the, okay, there is a hand. Chris? Yes, Chris? Okay, Chris's hand is down. Okay, thank you.
Hello, sir. I think I just cut off there. I'm not sure that you can hear me.
Is that Chris?
Yes, that's me.
Okay, Chris, yes.
Yes, I wanted to check. You said if, for example, the client has terminated the mandate with yourself as the attorney, you
Yes.
have to indicate that to the opposing legal representative.
Yes.
Now, within reasonable time. So I just want to check now as to how reasonable can be reasonable time, because perhaps are we talking about some weeks? Are we talking about days? Are we talking about some months?
Okay.
So that it's not becoming a problem now in the future to say no, but you didn't indicate within a reasonable time. Thank you.
Okay. Thank you for your question, Chris. Reasonableness will be determined by a number of aspects. If it is a matter in which there is litigation ensuing already, then the notice will have to be served as soon as possible as when the client tells you to withdraw. If it is if your client instructs you to withdraw a week before the case goes to court, for instance, that will be all the more reason for you to file the notice of withdrawal as soon as possible. And then what will happen on the day of, because the matter will be in court in a week's time, your client, now your erstwhile client, will either have obtained a new attorney who will then go to court on that day and possibly ask for a postponement because he did not have enough time, he or she did not have sufficient time to prepare for the trial or whatever the matter is. If the client has not found a new attorney by then, that client will attend court. That client will then tell the magistrate that the attorney was fired last week, or rather the mandate was terminated last week, and therefore there wasn't sufficient time within which to get an attorney present at court on that day. The court will not unreasonably allow the matter to proceed without the plaintiff having obtained a new attorney. The court will come to the assistance of that client and allow that client either a postponement to allow that client to get a new attorney of record, should that be the wish of the client, or the court will remove the matter from the roll to allow that attorney, that client, to get a new firm of attorneys. Now, if there is no litigation yet that has been initiated, and the client instructs the attorneys to withdraw, again, a reasonable time within which to notify the other side of the withdrawal is immediately when your client instructs you to withdraw. That is considered to be a reasonable time within which to withdraw. Chris, I hope that answers your question.
Sir. Yes, I'm answered. Thank you very much.
Thank you. The next hand that was up is that of Osman's.
Yeah, yes, Advocate. Am I audible?
Yes, Osman, you are audible.
Thank you so much. In the event where the client is a business and is represented by a director who's a sole director in the business, is there will I be correct in saying he will still need to make a mandate on behalf of the business, even though he's a sole director?
Yes, Chris, Osman, sorry, it will be a resolution.
Okay,
it will be a resolution that he basically had a meeting with himself at which he appointed himself to act on behalf of the company.
Thank you so much, Advocate. Thanks.
My pleasure, sir. Dimakato.
How are you?
I'm well, thanks. How are you?
I'm good. Is it possible for client who's a juristic person to terminate their mandate with, let's say, for example, the state attorney in Nelspruit, and then appoint state attorney in Pretoria to carry on with their matter, even though state attorney in Pretoria doesn't have jurisdiction over the matter?
Is it possible?
And if it is possible, then what happens? Because then state attorney Pretoria doesn't have jurisdiction over the matter.
Timakatso?
Huh?
When we started, we said we are going to focus on relevant questions with regards to the magistrate's court practice. Okay?
Yes.
Although I don't think that is relevant, I'm going to give you a quick answer.
Thank you so much.
Yes, state attorneys' offices have acted in matters where they do not have jurisdiction. And I mean jurisdiction, their office is situated outside of the office in which the litigation has been instituted. I have come across numerous such examples.
All right. Thank you so much, sir.
My pleasure, Dimakatso. All right, I'm going to now take a question by Apelele, which is on the group chat, before I look at the other two hands that are up. Under what reasons could I, as the attorney of record, elect to withdraw under Rule 52A? Okay. Let's see. Rule 52A. And I hope you all have your rules with you, because you will also have to look at them. And Rule 52 capital A says, where an attorney acting in any proceedings for a party ceases to act, each attorney shall forthwith deliver notice thereof to such party. All right, these are the cases which we had mentioned. Now, the reasons that an attorney would first of all withdraw under Rule 52 capital A is, first of all, if the client tells the attorney, I want you to withdraw, I no longer want you to be my representative. That's one example. A second reason that an attorney may withdraw is because the client is expecting the attorney to do something that is unethical. For instance, present a document which both the attorney and the client know to have been a fraudulent document, and the client insists that the attorney must present this document as an authentic document. The attorney is at liberty to withdraw as the attorney of record for the client in that particular case. Apelele, I hope that answers your question. We are going to the two hands now before I come to you, Emily. Osman, is your hand still up? Can you please put it down if it's still up from the last time? Tapedi, what is your question?
Thanks, Advocate. I just want to check, as you advised, that when one drafts a letter of engagement, one can indicate to the client that if the client does not pay within a particular time as agreed or period as agreed, you can suspend your services. I just want to check whether it is allowed that you can, over and above suspending the services, to charge interest for the late payment. Thank you.
Interest is a very tricky thing. And of course you are entitled to charge interest, but you need to follow the guidelines of the Legal Practice Council with regards to interest. And you must also explain to your client during that first consultation that should they not pay your account on time, it will attract interest. And you must also discuss with them the rate at which it will attract interest. And it is also advisable at that first consultation, when you discuss your fees, to draw up a fee agreement with your client in which it is meticulously set out which costs you will charge your client, and you will deal with the issue of interest in there as well.
Thank you,
I will just need to consult the legal practice rules with regards to interest. But interest, you are normally entitled to interest only when you have instituted legal proceedings against a client. But where you have not instituted legal proceedings, it must be by agreement between you and the client.
Thank you very much, Advocate.
My pleasure, sir. Okay, Tapedi, you may put your hand down. Babalwa, I'm coming to you now. There was a question on the chat by Emily. Can a practitioner withdraw in a case where a client does not pay the fees as agreed upon, not just put it on hold? Yes, an attorney may withdraw from a case if the client does not pay the fees as agreed. That is all the more reasons why you may withdraw. You will sometimes hear that, especially in court, when an attorney advises a magistrate that that attorney is withdrawing from a case, the attorney will say, I am not properly or fully instructed, Your Worship. That is why I am withdrawing. And the reason for that is, and the courts are even aware that where a client has not paid an attorney's fees, that attorney may withdraw. So yes, to answer your question, a practitioner may withdraw in a case where a client does not pay the fees as agreed upon. Are there any further questions? There is, let's see, who is next? I'm going to take one last question now before we move on. Whose hand was up? No more hands? Apelele. I now raise my hand.
Yes, thank you. Can you hear me?
Okay, we're going to take Apelele's question and then Jacob's last question, last one. Yes, Apelele?
Okay, I wanted to check.
Your connection is bad, Apelele.
Okay, let me just remove. Can you hear me now?
I can hear you clearer now.
All right, okay. I wanted to check with regards to withdrawing from you have to inform the clerk, the register of the court, and all other parties in the matter, like the opposing counsel. Is there ever a time whereby you'll be actually asked to state why you are withdrawing, or maybe the right to a client's confidentiality to block that from ever happening? Like, because I'm thinking in a case whereby your client wants you to do something which is illegal that will land you in jail, and you choose to withdraw as a result of that, would it ever be asked in court, why are you withdrawing?
You don't have to disclose if it's something of an unethical nature. You are not obliged to disclose the reason.
Right. Okay. No, thank you. Thank you, sir.
Pleasure, sir. Last question, Jacob.
Sir, is it imperative to assist a client who you know has a bad credit record?
Jacob, that's a difficult one. Because you must remember, first and foremost, our duty is to assist members of the public. Although money should not always be the primary consideration when you do so, we are also required to render services. I'm not saying you must render services for free, but not every client who walks through your door has got a red flag that will tell you I'm a bad creditor. And you will not always know that a client is a bad creditor. But take that client, assist the client, and you'll find that in some cases where you are unable to assist to get money out of your client, and you succeed on their behalf, and you win the costs order in your favor, in your client's favor as well, you may be able to recover some of your costs.
Thank you.
So I wouldn't say it's imperative on you to do so, but you will weigh up the options at the time when they present themselves.
Thanks.
Thank you, sir. All right. Thank you for your questions. Jacob, you may put your hand down and then we may move along. I've cleared this with your coordinator, and she's given us the go-ahead to take a break at 7 o'clock until 7:15. So we must please just make use of the time. At 7 o'clock until 7:15, we'll have a 15-minute break. All right. At the end of the first session on page 28, you see there are questions there, self-assessment questions. Question 1. I would like you to please, in your spare time, go through those questions. See if you can answer those questions. They will be your yardstick to tell you whether you understood what was explained to you in the first section. All right, so during your own time, go through those ones, please. Jacob, you may put your hand down, please. Right, now we are going to move on to demand. You must have heard of the term letter of demand. You may have even have been fortunate or unfortunate enough to have received such a letter of demand from a creditor. You will then be in that demand be referred to as the debtor, or your client whom you represent will be the creditor, and to whomever you are writing the letter of demand will be a debtor. Now, proceedings are normally preceded, legal proceedings, that is action or applications, are normally preceded by a demand to that person who is allegedly in default. And in that letter of demand, you request that person to, within a reasonable time, either do something or refrain from doing something. That is under normal circumstances. Before you go to court or you issue proceedings, you give them a written letter of demand. That letter becomes important when you seek costs against that party. Because if that person, after having received your letter of demand, decides to pay when they receive that letter of demand, decides to pay the money that you are suing them for, you are not entitled to any further costs. But if you, the attorney, Sonia, are you okay? Can you mute yourself, please? Thank you. If you, as the attorney now, without a letter of demand, issue summons against a party, after receiving summons, and before you take any further steps against that debtor, the debtor then pays the amount of money that is in the summons. The courts will not give you, the plaintiff, legal costs because you did not send a letter of demand. This is where you are not obliged to send a letter of demand. There are certain cases in which you are required, you are obliged to send a letter of demand before you institute legal proceedings. But in cases where you are not obliged to send a letter of demand, and the party, the debtor pays that debt after receiving summons, the plaintiff may not be entitled to legal costs because there was no demand before summons. Now, this tells you that there is a distinction to be drawn between cases in which legal demand is required or it is obliged, and also cases where it is not obligatory to send a demand. In the case of a claim against an organ of state. Now, we all know what an organ of state is. But for those of us who don't know, just to remind you, a government department, be it a national department, a provincial department, or even a municipality, in terms of specific legislation known as the institution of legal proceedings against certain organs of State Act number 40 of 2002, when you are instituting legal proceedings against an organ of state, you have to first start with a letter of demand. That letter of demand, in terms of Section 3 of that act I've just mentioned, is also referred to as a statutory notice. In other words, you must tell that organ of state, I am suing you for a debt. In other words, this money that I'm suing you for is a debt in terms of the act. And because it is a debt and you are an organ of state, I am giving you notice that I intend to sue you, either by application or by action. But you must give that party notice within 6 months of becoming aware of the cause of action. Now, the cause of action arises on the date upon which the facts on which your claim is based become known to you, the plaintiff. But at this stage, you are not the plaintiff yet because you are only doing this for purposes of giving a written notice to that organ of state. In your summons, normally a combined summons, which will be accompanied by particulars of claim. And in your particulars of claim, there will be a specific paragraph which deals with that notice in terms of Section 3 of Act 40 of 2002. And in there you will say the following, or something to the following effect. Before instituting these proceedings, the plaintiff complied with the provisions of Section 3 of the Institution of Legal Proceedings against Certain Organs of State Act number 40 of 2002. Then you will further state that on the 12th of March 2022, the plaintiff caused to be delivered to the defendant a statutory notice notifying the defendant of this impending action. A copy of the statutory notice is annexed hereto and marked A. Full stop. You've now satisfied the requirement that you have complied with Section 3 of Act 40 of 2002. There are other examples of causes of action where you are compelled to give notice to the other party before instituting proceedings. Now, a promissory note or an acknowledgement of debt which is payable on demand requires you to give notice to that party before instituting proceedings. Also, the National Credit Act 34 of 2005, also in terms of Section 129 1A or Section 86 subsection 10, requires that you give notice to the debtor of your intention to institute legal proceedings against them. In fact, the National Credit Act goes further than that. The National Credit Act even says that in terms of Section 130, you have to give the debtor sufficient time within which to do certain things. And these things are the following. Rather, Section 129. You draw the defaulter's attention to advise them to refer the agreement to a debt counselor. So that's the first option you have to exercise as a creditor in terms of the National Credit Act. Section 129 also says that you must give the debtor, bring to their attention that should they regard themselves unable to settle their monthly debts on time, or an ombudsman with jurisdiction, an alternative resolution agent, or a consumer court to lodge a dispute and have the matter resolved. All of this has to be done, of course, within a period of 20 days of you being sent that letter. And if a consumer or a debtor fails to act within those 20 days by following any of the steps which I've just mentioned now, then the creditor may institute legal proceedings against that debtor. Now, to step back a bit to deal with the institution of legal proceedings against certain organs of state act. That act makes it compulsory for a creditor to send that notice to the organ of state before instituting legal proceedings. And I said it must be done within 6 months of becoming aware of the facts which give rise. But more importantly, another requirement for a person to become aware of the facts or to complete their course of action is for them to know who the debtor is. In other words, who must they sue? Okay, before I continue here, I see there are some questions here. Caitlin Ritt is asking, can you please repeat your explanation of a letter of demand? Your sound is going on and off my side. Not sure if I can't read that. Not sure if it is only me. Okay, Emily answered you there. It is the same as when one refuses the offer made in a settlement agreement only to find out that the court orders the same amount, then the plaintiff will not be entitled to costs ordered. Okay, let's see if Caitlin, I hope you can hear me now, Caitlin. There are two instances in which letters of demand are written. In the one instance, it is a requirement of legislation, such as I'm explaining now in terms of the Institution of Legal Proceedings Act, as well as the National Credit Act. It is a requirement that you send a letter of demand to a debtor before instituting proceedings. Your cause of action will be incomplete if you have not done that. Roxanne, look at Annika's response, please. The second instance in terms of which a letter of demand is written is when it is not a legal requirement, either by statute or otherwise, that a letter of demand be sent. In that instance, it will stand you, the creditor, in good stead, in that you will be entitled to legal costs if after receiving summons, the debtor pays the amount claimed. If you've not written letter of demand and instituted legal proceedings without that letter of demand, you may not be entitled to costs if the defendant settles the debt within a reasonable period after receiving summons. And that you will find if you just bear with me, that you will find on page 30 in the case of Butler versus Nigel Cartage Company, which is a 1933 law report, TPD, Transvaal Provincial Division, page 218 at page 220. You will also find the relevance thereof in Venter versus Venter. It's a 1949 volume 1 SA law report, which can be found at page 768, paragraph A, at page 778. We are back to the Institution of Legal Proceedings Against Certain Organs of States Act. And I said that it must first of all be a debt. So a claim against the MEC for health in respect of medical negligence is a debt in terms of the Legal Proceedings Against Certain Organs of States Act. And the MEC for health, the department which the MEC for health represents, is an organ of state. In terms of the Act. And according to the Act, an organ of state also includes a municipality, any functionary or institution exercising a power or performing a function under the Constitution or a provincial constitution. It also includes the South African Maritime Safety Authority. An organ of state also includes the South African National Roads Agency Limited, SANRAL. So if you want to know what is an organ of state, You look at section 1, subsection 1 of the Act, and that will tell you. It will also tell you what is a debt. Now, what happens if a party does not send out a notice, a statutory notice, within the required 6 months or at all? There is relief for that party. In terms of the Act, that party may apply to the court having jurisdiction for condonation of the late filing or of the no filing at all. And in that application for condonation, the party seeking condonation will have to extensively set out why that party could not give notice within the required 6 months or at all. And in your in your application, you will have to set out facts to show cause and to explain the delay. You need to explain the entire period during which you did not give notice. Why did you not give notice? I was in a coma. I could not wake up. I didn't know about it. I'm a lay person. I'm a rural person. I'm uneducated. I'm illiterate. I know nothing about these things. It's by pure chance that I met so-and-so 2 years later. And it's only now that that I know about it because I met an attorney and she explained it to me only now. You must also, in your application for condonation, in your founding affidavit, satisfy the court that your debt has not been extinguished by prescription. In other words, you are still within the 3-year period within which to institute legal action against the debtor. You must also satisfy the court that you have shown good cause for your failure not to send the notice within time. And lastly, you must also satisfy the court that the organ of state was not unreasonably prejudiced by your failure to send them the notice. Those 3 things are very important. If you are unable to show all 3, 2 of them, or 1 of those things, then you may be in trouble of not having your condonation granted in those particular instances. Section 4 of the Act specifically tells you how you may deliver the notice to that organ of state. Number 1, by delivering it by hand, or by sending it by certified mail, or by sending it by electronic mail, or by transmitting it by facsimile. Those are the only ways in which you can send the notice, right? I noticed that it's 7 o'clock now. As we said, we will take a break at 7 o'clock until 7:15. When we return at 7:15, we will look at our questions that we have, and we will try to answer those questions before we start our next session at 7:15. Thank you. See you speak to you at 7:15. Let's all try to be back here by 7:15, please. Thank you. All right, we are back. Hope you all had a deserved break. I'm going to, as I said before our break, attend to some questions. And I'm going to start up there on the questions. Jeffrey Mariri wants to know, how do you institute legal proceedings against the organ of state for damages or matter not covered in Section 3.1? What is Section 3.1, Jeffrey?
I was referring to Section 3.1, where it is a notice of intended legal proceedings against the organ of state.
Now,
And
what
3.1
type of damages are not covered in Section 3.1? Hello, Jeffrey. Let's look at 3.1. 3.1 says, no legal proceedings for recovery of a debt may be instituted against an organ of state unless the creditor has given the organ of state in question notice in writing of his or her intention to institute the legal proceedings in question, or the organ of state in question has consented in writing to the institution of that legal proceeding without such notice, or upon receipt of a notice which does not comply with all the requirements set out in subsection 2.
Okay, here I'm referring to a matter which is not about the recovery of a debt. Let's say maybe the organ of state has wronged me in one way or another. Maybe they've damaged my vehicle, they've made me to suffer for certain damages, maybe loss of income due to unfair dismissal or whatever thing.
Okay, Jeffrey, you have to look at the act as a whole. Okay, in this case, you have to look at whether, first of all, it constitutes a debt. Right? Does it constitute a debt? I cannot see how it is envisaged that it does not fall within Section 3, because Section 3 is the section that deals with the notice. Section 3 does not say what type of debt. It just says a debt may be instituted against the state. If it falls within the meaning of a debt, Section 3 will apply. Are you with me?
I'm with you, but what I'm trying to say here, there's no debt against the state for now, or for organ of state. Maybe I want to sue them for certain damages. That's what I wanted to ask.
Can I come in?
Debt is known. They say that the debt I'm claiming is R1. So in this case, I do not have a specific amount or debt, but whatever figure I'm coming up with, they can still dispute it or agree to it. I guess I'm saying if I sue them for damages, maybe to loss of income or whatever it's in. Thank you, sir.
Okay. Someone wanted to come in?
Hi, hello.
Hello, yes.
I was of the opinion that maybe one first has to say to place the whoever you are litigating against immoral. In other words, they must admit that they are immoral by you making them not realize that they owe they owe. And that's when maybe the actual claim is legitimatized, and then, yeah, I don't know if I'm wrong.
Okay. Now, I think we are veering off the topic now. But thank you for that response. Jeffrey, if you are instituting legal proceedings against an organ of state, and it is a debt, let us say it is for loss of income, that debt would still fall within the meaning of the Act. And in terms of Section 3, you still have to give statutory notice in respect of that claim.
Okay, I'm clear now. Yeah.
Are you clear now on that one?
Yeah, I got it now.
Yes, it's still a debt. If it does not fall within the meaning of a debt in terms of the Act, then you do not have to give notice. Because, and then it must also not be an organ of state. I cannot see how you can escape it. For just to be safe, my advice would be, as long as it's an organ of state, issue a statutory notice, just to be safe. All right? Okay. Mtunzi, when claiming loss of income at RAF on behalf of the client, would you need to send a letter of demand? Mtunzi, the Road Accident Fund Act requires that before you institute legal proceedings against the Road Accident Fund, you lodge a claim. And if your claim is for loss of income, your claim would have been lodged before instituting proceedings. Therefore, your claim would amount to demand. Okay? Onethemba, Otembela Matikizela, if you are late by 1 day, you still need to apply for condonation, or is there some leeway? Yes, you have to apply for condonation even if you are late by 1 day. As long as you can explain the delay and the reason for the delay. There is no leeway. You still have to seek condonation from the court. It's the only way, it's the only leeway you have is by seeking condonation from the court. Teresa, in regards of a natural person and having served the demand and the matter proceeds to go to court, when I pray for legal costs, can I also pray for them to cover, for instance, transport fees in circumstances I had to travel to the court that has jurisdiction? And if the answer be in the affirmative, how can it be quantified? Thank you. Okay, let me see if I understand your question. In regards to a natural person and having served the demand and the matter proceeds to go to court, when I pray for legal costs, can I also pray for them to cover, for instance, transport fees in circumstances I have to travel to the court that has jurisdiction? If you are successful in your claim and you are awarded costs in your favor, legal costs, you would have to submit your costs to a taxing master at the court. And in your costs, you will include costs for traveling. And if the taxing master feels that you are entitled to those costs, then you will be allowed those costs. You will have to prove your expenses in terms of traveling. There is a tariff for traveling in terms of kilometers and time spent. So that will be the situation there. Jeffrey Mariri again, is condonation applicable on prescribed matters related to RAF? I'm afraid this is not a relevant question for our purposes here today. The condonation we are speaking of is in terms of the demand. Let us not lose focus here. We are talking about demand, and only condonation may be sought in terms of Act 40 of 2002, which is the Institution of Legal Proceedings Against Certain Organ of States Act. Please do not confuse the issues here, guys. Okay? Focus and pay attention, please. Nyanesis we Budaza. So condonation reasons are your reasons as a plaintiff or defendant, or are the reasons of your attorney condonation. Nyanesis, where I'm assuming your question relates to condonation in respect of the Institution of Legal Proceedings Act. If it's not, I'm not going to answer that. But if it is, remember, you are the plaintiff. And you are the one who has to show that you've given notice to the defendant, who will be the organ of state. And if you are the plaintiff, you will be seeking condonation. But of course, your attorney will prepare the papers on your behalf. Your attorney will draft your notice of motion. Your attorney will draft your founding affidavit in your name as the plaintiff, setting out your reasons as the plaintiff for your failure to comply with the requirements for statutory notice. Nyanesizwe, again, I presume that they are the plaintiff's reasons as they are the ones in default. Okay, I don't know if you are answering your question there. Okay, I think Emily is answering Nyanesizwe there. And there Nyanesizwe says, thanks to Emily. Reason I am asking a lecture has made an example of being uneducated. Then I was keen to know how possible to make that defense, whereas you are presented by skilled person. Remember, you are only represented by the skilled person when they are instituting your claim. Okay? And at that stage only will you become represented. But before, when the cause of action arose, you were not represented. And you therefore did not know that you had a claim because you are uneducated or illiterate, as it was then. But you must also have realized within a reasonable time. You cannot, for instance, say only after 5 or 8 years did you become aware because you were illiterate. You have to become aware within a reasonable time. Okay? Okay, can I ask that I be the only one to please answer questions? They are directed at me anyway. Emily, again, Jeffrey, Mariri, Section 23(3) of the RAF Act does not mention anything with regards to condonation after the period to claim has expired. Be sure to read upon the case of Ralph Mokoena, where condonation was considered. I doubt the provision for state organs extends to RAF. Well said, Emily. You've answered him. Good. Now that we've got that out of the way, we will now move along. Okay, once again, at the end of your notes on page 37, there are self-assessment questions there. Question 2, where you are required to draft a letter of demand in respect of claim for damages, and then a letter of demand in terms of the National Credit Act, and then one in terms of the Alienation of Land Act, with the purchase price is payable in installments. Is a demand of, in terms of Section 19, necessary? Okay, let us look at, before we move on, I want us to Okay, just bear with me a moment, please. Okay, we are going to move on to jurisdiction now. Right, now you must have come across this word jurisdiction before. And jurisdiction is the competence of a court to hear a matter, to determine the issues between the parties. In other words, the power that the court has to hear that. It's either the court is empowered or it is not. Right? Now, there are certain jurisdictional limits which are imposed by legislation on the magistrates' courts. Previously, it was only the district court of the magistrates' court that was competent or had jurisdiction to hear civil courts, civil cases. That power has since been extended to the regional court. Now, the regional court also has the jurisdiction to hear civil matters. And one particular instance in which the regional court now has jurisdiction is that of divorces. So a regional court can now hear divorces also. Divorce cases were reserved for the High Court only because they dealt with the status of a person. But now that privilege has been extended to the regional court as well. The answers, the self-assessment questions at the end of your sections that we're dealing with do not have answers, but they will assist you to understand the contents of the subjects before them. So it's a way of testing yourself to see if you understand the concepts. You read through the notes, and at the end thereof, if you must be able to answer those self-assessment questions. Right, now, one of the jurisdictional limits of the magistrates' court is that of monetary limit. The district court has a monetary limit of up to 200,000 rands. In other words, you may sue a party out of the district magistrates' court only if the debt is under 200,000 rand, up to a maximum of 200,000 rands. Also, you may sue a party for damages out of the regional court from 201,000 rands up to 400,000 rands. Thank you, Madre Nelson. Rosalind, did you see? The answers are on section F of the textbook. So there's section F. For everyone else who wants to know, section F contains the answers to your questions. But please try to do the answers on your own before you go to the answers, okay? So we know now what the limits is. And everything above 400,000 rands, 401,000 and more, has to go to the High Court. And that was established. If you look at the case of Minister of Police versus the regional magistrate, Oates Warren and others, it's a 2014 case. Read that case as well, which deals with the jurisdiction of the district court. Our courts also from time to time. Elizabeth, can you please mute your mic? We can hear your dishes there in the background. Thank you. Now, the various courts also have practice directives in terms of which and how things are done in that court. It is common practice in the high courts, but the magistrates' courts also have practice directives which are issued and which are also at the back of this training guide. You will find them there, examples of them. But for your own magisterial districts and regions, inquire as to which one applies to your particular division, particular district or region. And you have to always update yourself with regards to these practice directives. They are updated regularly. So are the rules. Make sure that the rules and the act, you have the updated versions at all times. Yes, Apelele. That is correct. So update yourself all the time. Make sure you have updated material. Make sure you have the rules, the act, and make sure when you consult case law, you consult updated cases. If a case has been amended or appealed, if a case has been appealed, if it's gone on appeal, you should know when it's been appealed, or when there was another case which did away with the principle in another case, you must know when that case has been appealed. To make sure that you read the most updated of all your legal sources when you are dealing with issues, more particularly the jurisdiction. There are some important cases, Graafrenet Municipality versus Van Reyneveld's Pass Irrigation Board. Also look at Ewing McDonald and Company Limited versus M&M Products, a 1991 case. Right, now, it's important for you to establish jurisdiction in all your cases, whether it is by way of an action or whether it is by way of an application. Yes, Kennedy, there is a difference if the matter is related to immovable property. Still, what happens is, in order to determine the jurisdiction in terms of the monetary limit, they will look at the value of the immovable property and then apply that to determine which court has jurisdiction, which is what you as the attorney must do when you are planning to institute proceedings. In respect of rent, the court will look at the value of the property, but the value of the property according to the owner of the property, not the debtor or the tenant. That is what the court will look at, the value of the property in addition to the rental owed. So it's important that you establish jurisdiction in your pleadings as well as your affidavits in applications. I've noticed many of your colleagues, when they draft particulars of claim, they will make the allegation that the above honorable court has the jurisdiction to hear this matter. Full stop. They do not tell the court how the court has jurisdiction, and their opponents, when they plead to that pleading, do not take issue with it. That makes it excipiable because you've not established jurisdiction. In fact, you've just made an allegation that the court has jurisdiction. You've not told the court how it has jurisdiction. For instance, when you say that the court has jurisdiction, you must say the following: the defendant resides within the area of jurisdiction of the court. And in the previous paragraph, you will have described the defendant and given the defendant's address, which establishes whether it is within the jurisdiction of the court or not. You will say the defendant carries on business within the area of jurisdiction of the above honorable court. And once again, you will have stated that the address where they carry on business as a defendant. Or you can say in support of jurisdiction that the plaintiff and defendant both reside within the area of jurisdiction of the above honorable court. Or you can say, in addition to that, the whole cause of action arose within the jurisdiction of the court, and the facts that follow will support that contention. Or you can say the sale agreement or the contract, which is the subject matter of this cause of action, was concluded in the area of jurisdiction of the above honorable court. You will have established jurisdiction then only when you've disclosed those facts or you've made those allegations in both your action and in your application. In your application, it will be done in your founding affidavit where you address the issue of jurisdiction. Now, in addition to those jurisdictional points, a party, two parties, in fact, may, where a court does not have jurisdiction, agree or consent to the jurisdiction of a particular court. And this is common in mortgage bonds, acknowledgements of debt, surety agreements, where parties agree that a particular court, which does not normally have jurisdiction, shall have jurisdiction in respect of that particular claim. Section 45 of the Act, of the Magistrates Courts Act number 32 of 1944, specifically provides that parties may agree or consent that a court has jurisdiction in respect of the monetary value. But in addition to the monetary value, the other jurisdictional requirements must have been met. In other words, if it was not for the money only, does the defendant, for instance, reside within the area of jurisdiction of the court? Because one of the important factors to determine jurisdiction is that you must follow the defendant or you must follow the respondent. Now, if the respondent does not, or the defendant does not reside in the jurisdiction of the court, and the jurisdictional limit of the court has been exceeded, the parties cannot agree, they cannot consent to that court having jurisdiction. They can, but they may not, because the court will say, no, you have not met the other requirements for to establish jurisdiction. So it's only if the other requirements for jurisdiction have been established that the court will accept parties consenting to the jurisdiction of the court in terms of the monetary value of the claim. Nyanesizwe, what happened when their initial claim was 200,000 Rand and counter offer is 250,000 Rand? Will the matter be settled in district or regional court? I see you are trying to make my life difficult here. Okay. When initially the claim was 200,000 Rands and the counter offer is 250,000 Rand. You issued summons in the district court. The district court is limited to 200,000 Rands. How do you then justify an offer higher than 250,000 Rands? You're not entitled. You are entitled to a higher offer, but if it's by agreement between the parties, yes, then you may take an offer. Then you may take an offer in. Then you may take an offer in that court that exceeds the jurisdictional amount. But as I said earlier on, the requirements, the other requirements must be there. But in this case, the requirements will be there, Nyanesizwe. So the parties can agree to take an order for a higher amount in that court. Kaylin, we're not, I don't go according to page numbers. I jump around as a teacher would, depending on the relevance of it. Okay? So you'll have to catch up with me and just try to figure out. I would like you to actually listen to what I'm saying. Debbie has a question. Why does jurisdiction follow the defendant or respondent and not the applicant or plaintiff? Because it is the rule. That is the rule. We do things in terms of rules, and the rules dictate how we do things. So if the rule tells you that you follow the defendant or the respondent, that is what you do. It is one of the ways of establishing jurisdiction and in terms of the rules. Just a moment, I just want to find the appropriate rule for you. So are you happy, Debbie? Okay. All right. Right now, the section 29, right, of the Act, we will look at jurisdiction more closely. And Debbie, hopefully we'll come to you as well there with your question. Jurisdiction in respect of persons is dealt with under section 29, 28 in terms of persons and 29 in terms of causes of action. Now, section 28, first of all, says the persons in respect of whom the court shall have jurisdiction shall be the following and no other. Any person who resides, carries on business, or is employed within the district or regional division. Any partnership which has business premises situated or any member whereof resides within the district or regional division. Any person, whatever, in respect of any proceedings incidental to any action or proceeding instituted in the court by such person, himself or herself. Any person, whether or not he or she resides, carries on business, or is employed within the districts or regional division, if the cause of action arose wholly within the district or regional division. So the rationale there is it's not for the comfort of the plaintiff to choose jurisdiction, but the plaintiff must follow the defendant where the defendant resides or where the respondent resides or carries on business. That is one of the rationale behind the issue of jurisdiction, of following the defendant or the respondent. Now, Section 29 deals with jurisdiction in respect of causes of action. Now, this will determine at which level of court you must issue your summons, okay? From which level. A court shall have jurisdiction in actions in which is claimed the delivery or transfer of any property, whether that property is movable or immovable, but it does not exceed in value the amount determined by the minister from time to time by notice. And for now, we know the value to be, in the regional court, 400,000 rands. In the district court, 200,000 rand, the maximum. Secondly, the court shall have jurisdiction in actions or ejectment against the occupier of any premises or land within the district or regional division, provided that where the right of occupation of any such premises or land is in dispute between the parties, such right does not exceed the amount determined by the minister from time to time in the Gazette in clear value to the occupier. So here already you can see the value is important. So you should always keep in mind the regional limit and the district limit, 200,000 and 400,000 rands, and apply that. Now, when they say here, which is determined by the minister from time to time, in the Gazette. So the minister will from time to time issue in the government Gazette a notice in terms of which the properties will be affected, the value of the properties, the amounts to be determined. You need to, when you are faced with these causes of action, go and consult the relevant government Gazette to make sure that the amounts were set there by the minister and what those amounts are. Thirdly, the court shall have jurisdiction in actions for the determination of a right of way, notwithstanding the provisions of Section 46. Now, what is Section 46? Section 46 deals with matters beyond the jurisdiction. Okay, so you will not even look at the provisions of Section 46, but any action for the determination of a right of way the court shall have jurisdiction in such matters. Up to you to decide which one, if you want to go regional or you want to go district. D, actions on or, this is now where the court shall have jurisdiction too, the magistrate's court. Actions on or arising out of a liquid document. A liquid document? What is a liquid document? Check, promissory note with no restriction, or a mortgage bond where the claim does not exceed the amount determined by the minister from time to time. 200,000, it will be 200,000 in the district, 400,000 in the regional. There's no restriction to the type of liquid document, not the amount. The amount is still important here. So you can't institute legal proceedings on a liquid document with a value more than 400,000 rand in the regional court and more than 200,000 rand in the district court. Kennedy, you are jumping the gun here, my friend. We are coming to that issue. But let me answer the question. If a party wishes to institute proceedings out of a court, be it a district court or a regional court, and that court, the particular court that was chosen, the amount for which you instituted the claim exceeds the jurisdiction of that court, you may not be entitled to the full amount. You may be entitled to the amount of the maximum of that court. And you may abandon part of your judgment of the amount which exceeds the limit of that court. So yes, the answer to your question is yes, a plaintiff can abandon a portion of an amount. But why abandon a portion of an amount if you institute it out of the correct court in the first place? Make absolutely sure that you are in the correct court. Make absolutely sure that you institute your proceedings out of the correct court. If you institute an RAF claim out of the district court for 200,000 rands, and you know there is the possibility that it may fall within the jurisdiction of the regional court of 250,000 rands, why in the first place issue out of the district court? Go straight to the regional court, knowing that you have a better chance of doing it. Conversely to that, many practitioners institute proceedings out of the High Court, and they end up being awarded damages on the scale of the regional court or the district court. The High Court will be alive to the fact that your claim does not fall within the jurisdictional limit of the High Court and award you costs on the appropriate scale. So be careful out of which court you institute your proceedings. Make sure that it is flexible and that you are able to, without having to compromise your client's case. Incidentally, I represented an organ of state in a magistrate's court case where the organ of state was sued out of the district court for an amount of 200,000 rands. After the proceedings had been instituted, it became apparent that the plaintiff's damages far exceeded the damages claimed of 200,000 rands. The plaintiff then tried to convince the defendant to agree to the jurisdiction of the district court for purposes of settlement of the claim. The defendant refused, and the plaintiff's claim was limited to 200,000 rands only, all because of a mistake made by the attorneys for the plaintiff. So you need to listen very carefully. Your client does not know about jurisdiction and jurisdictional limits. That is where you, the attorney, will come in and you have to guide your client accordingly. So rather err on the side of caution and institute proceedings out of the higher court where you know you may be entitled to a higher award for damages, and not shortchange your client by issuing summons out or proceedings out of a lower court. Okay, Portia wants to know, can you divide one claim it bit by bit for you to meet jurisdiction requirement? No, Portia, because now you are multiplying your one cause of action to come within the jurisdictional limit. You remember, each claim has its own cause of action. You cannot split one cause of action into 3 causes of action to come within the jurisdictional limit. If your claim falls within the regional limit, go to the regional court. If your claim falls within the High Court jurisdiction, to be safe, institute proceedings out of the High Court. Then you do not have to divide your claim bit by bit. Right, the court, the magistrate's court also has jurisdiction actions or arising out of any credit agreement as defined in Section 1 of the National Credit Act. Also actions in terms of Section 16 of the Matrimonial Property Act. And that act, that section deals with where the claim or the value of the property in dispute does not exceed the amount determined by the minister, 200,000 or 400,000 rand. So Matrimonial Property Act speaks to divorce automatically. So you can institute a divorce action out of the regional court if the property, right? The value of the property in dispute does not exceed 400,000 rands. Actions, the court also has jurisdiction, shall have jurisdiction in actions which include an application for liquidation in terms of the Closed Corporations Act. Now remember, the Closed Corporation Act was repealed, and however, there are still certain sections of the Closed Corporations Act, but they are no longer closed corporations being registered. Everyone now has to register in terms of the Companies Act. But where those closed corporations are still in existence, and one wants to bring an action, an application for liquidation of a closed corporation, the regional court will have jurisdiction. Okay? Now, actions other than those already mentioned in this section, where the claim or the value of the matter in dispute does not exceed the amount which is by the minister. So any other action, right, which you would ordinarily be able to bring in the regional court because of the monetary value, or the district court because of the 200,000 rands, the court in that case, those courts will have jurisdiction in those types of actions. Yes, Zetu.
Hello, sir.
Hello.
Yes, I wanted to ask with regards to the Matrimonial Act that you spoke about, and you spoke about property. In what sense? I'm a bit confused, as I can't think about a scenario. Is it property as in maybe a house that the couple that's divorcing now is taking to court, or is it the estate of the two people? I'm not getting it. Could you please explain that for me?
Okay. In a moment for you, just a moment for me.
Okay.
Right now, it is not specified what type of property it is. Because property could be movable property, it could also be immovable property. So as long as the value of the property concerned does not exceed the jurisdictional limit of the magistrates of the regional court. Are you with me? Are you happy with that answer?
Not really, but
what would you like to
agree.
hear?
I guess I could read some more or research some more.
Okay.
Because I think I want like a specific scenario for me to actually understand. But I think I do get the gist of what you're saying.
Yeah. You must remember, matrimonial property applies to divorce, would apply to divorce in this case. And between them, you must remember, a married couple has as property between the two of themselves immovable property, which is a house or a caravan or whatever, or as well as the furniture in that house. And the furniture and the house form part of the joint estate. So property would refer to movable and immovable property. Are you satisfied with that?
Yes, that makes much more sense. Thank you so much.
My pleasure. Right, now the Section 29(1) of the National Credit Act now, by virtue of that section, the Act established a National Credit Tribunal, right? And the decisions, the judgments, and the orders of that tribunal are binding on a magistrate's court. So the magistrate's court is bound to follow the judgments, decisions, and orders of the National Credit Tribunal. So the tribunal is possessed with jurisdiction to hear matters in terms of the National Credit Act, to determine those matters. But a magistrate's court is also empowered by the National Credit Act to suspend a reckless credit agreement, to declare and relieve over indebtedness, and to rearrange a consumer's obligations. So matters falling under the National Credit Act, magistrates' courts have unlimited monetary jurisdiction by virtue of the provisions of Section 172, subsection 2 of the National Credit Act. Mr. Terence Mabuela.
Yes, Advocate. Thank you very much for the opportunity. Yes, I wanted to check in terms of Section 29(1). You did mention that the orders they are binding on the magistrate court. So, which means if a party were not to be satisfied, then they will then have to appeal to the High Court. Am I right, or is it supposed to be the regional court?
No, you are quite right. You are quite right. You will have to. The magistrates' court, you must remember, is not an appeal court. It's a court of first instance. So you can only appeal decisions of the tribunal to the High Court.
Thank you, sir.
Are you satisfied with that response?
Yes, I am. Thank you, Advocate. Thank you.
Okay, sir. Thank you. Nyanisizwe, your request will be adhered to, sir, at the end of the class. Right. Page 42, for those who are going according to page numbers. On the issue of costs, in the case of Nedbank Limited versus Mateman and another, the full bench on the 7th of December 2007 ruled that a high court has concurrent jurisdiction with a magistrate's court, but that a plaintiff ran the risk of only being awarded costs on a magistrate's court scale if he instituted action in a high court for a claim which traditionally falls within the jurisdiction of a magistrate's court. Does that sound familiar? I mentioned it earlier. If you institute legal proceedings in the high court and you are awarded damages on a magistrate's court scale, in other words, your quantum is under 400,000 rands or under 200,000 rand, the court will award you costs on the appropriate lower scale. Okay, there's Caitlin. Although Section 29 provides a list of cause of actions which determines jurisdiction based on value, Section 45 can still be followed where the value exceeds the determined amount. In the instance all other jurisdictional requirements have been met. Yes, Caitlin, that is correct. So if in terms of Section 45, the parties agree that the court has jurisdiction in terms of the amount, which is higher than the jurisdiction of the court concerned, the parties give the court consent to have jurisdiction in respect of the amount. Even if Section 129 provides that list, yes, you can still use Section 45 and agree, provided that all the other jurisdictional requirements are met. Correct. Okay. Now, Section 29, 1B, where the right of occupation is in dispute. In order to oust the magistrate's jurisdiction under this subsection, the defendant must show that there is, 1, a bona fide dispute as to the right of occupation, and 2, that the right of occupation is worth less than 200,000 rand in the district court and 400,000 rand in the regional court to the occupier. Okay? Read van der Westhuizen versus Peterson, 1922 TPD decision. Also read Jordan versus the Beer Skippers and the ander. Langham Court versus Mavro Matey. So the value to the occupier of a right of occupation of immovable property is the economic advantage which he enjoys from the exercise of that right, not the value of the property. But he has to set out in his cause of action that it is the value which he attaches to it and not which he enjoys from the exercise of that right, and not the market value of the property, to bring it within the correct jurisdiction. So matters which are personal to the occupier must be taken into account, although the approach in assessing the value is an objective one. In other words, the occupier must not, to suit his own needs and to bring the matter within the jurisdiction for himself, now want to attach a value in order to bring it within the jurisdiction. It must do so objectively. And where the rent is the measure of value to the landlord not necessarily to the occupier. These are all the circumstances which are taken into consideration. That, wait a minute, I am the owner of this property. I'm the landlord, not you. You are the occupier. You can't attach a value to this property. I say that this property is valued at so much, and therefore this court does not have jurisdiction. So the onus is on each party to prove its own case in respect of jurisdiction. Now, in terms of the evictions, in terms of the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, also known as PI, the if the property concerned is occupied by an unlawful occupier, proceedings there will include application proceedings, and there the applicant must prove that it falls within the jurisdiction of the court concerned. It may either be land or it may be a building, but it must be a residential building or premises and not commercial. PI does not apply to commercial property. And there you need to read the case of McNeil versus Aspeling, Western Cape Division, case number A85 of 2018. The judgment was delivered on 2018. What's important about that case is the procedure which was set out for those applications, right? In that case was only applicable to the Western Cape and no other jurisdictions due to the principle of stare decisis, stand by the court's decision. But it may be argued and left to the discretion of another court other than the Western Cape High Court to accept or not. Dolly, look at page 43, McNeil versus Aspeling, Western Cape Division. You're a lawyer. Cases are never too many. We rely on cases, Zanele. That is where our law comes from. Right. Now, examples of where material facts form part of the cause of action and which must be proved. In the instance of a contract of sale, the conclusion of the contract, right? The delivery of the goods and the payment and breach must have taken place within the same district. Similarly, so when a contract is concluded over the telephone, where the one person sits in one place and the other one in another place, the acceptance of the offer will come to the attention of the person where they receive the offer. It's very tricky when it comes to telephonic contracts. In the same way, when a contract is concluded, the delivery of the goods and the payment and breach must have all taken place within the same district. If one of those things has taken place outside of the district, it's out in terms of jurisdiction. But it's up to the defendant to prove and to allege and prove that. The plaintiff has to prove that the allegation, prove that the conclusion of the agreement and that both the offer and acceptance must be done in the same district. Otherwise, the whole cause of action does not arise within the district. So the plaintiff will then have to make use of section 28, 1A, which is in respect of jurisdictions in respect of persons. Don't worry, this will all make sense to you if you read over it again. Okay? But don't stress too much about it. Zanele, here's another one for you. Base versus Root. Malherbe versus Britstown Municipality. Driftwood Properties versus McLean. These are all on page 44, by the way. Cape Explosives Works Limited versus SA Oil and Fat Industries Limited. Kerguelen Sealing and Whaling Company Limited versus Commissioner of Inland Revenue. Read those cases with regards to jurisdiction. Now, the facts which need to be proved in respect of checks. A check is drawn on a specified branch of a bank. It's presented for payment. It is presented for payment at that branch, and it is dishonored at the same branch. Therefore, the court of the place where the bank on which the check is drawn is situated and where the check is presented for payment will always have jurisdiction. But you need not really worry about checks, because from December 2020, checks have they stopped using checks. Okay, Kennedy and Yanisizwe seem to have jumped the gun there. Is it wholly requirement of the cause of action? I don't understand your question, Apelele. The cause of action arose wholly within the jurisdiction of the court. Not in terms of the examples I've just made now. Because in terms of the example, the whole cause of action did not arise in the court, because, for instance, come back to the issue of the contract of sale. First of all, the contract must be concluded in the area of jurisdiction. The delivery of the goods must take place in the area of jurisdiction. The payment must take place in the same area. The breach must have taken place within the same district. If one of those elements is missing, then you cannot say the whole cause of action arose within the court. It is up to the defendant to then deny that fact when it pleads to it and say, no, the whole cause did not arise out of the court, the jurisdiction of the court, and therefore the plaintiff has not established jurisdiction. Okay. Lastly, in a motor vehicle collision, all the elements in a motor collision case always occur within the jurisdiction of the court within which the district collision took place. You do not find an accident happening in East London, and then the accident continues to happen in Grahamstown. It's not possible. That's not going to happen. So in all cases of an accident, motor vehicle collision, where you rely on the whole cause of action arising there, you will definitely succeed in proving that the whole cause of action arose in that area of jurisdiction of the court. Okay, the next topic we're about to deal with is rather lengthy, and I see that we have 6 minutes left before we are to adjourn until tomorrow. What I'm going to suggest to you is that for tomorrow, and in response to let me see, who is it? Someone asked, oh, Nyanesizwe. These are the topics which I need you to prepare for tomorrow. We are going to continue with jurisdiction and conclude jurisdiction. After which we are going to deal with forms of proceedings and your action proceedings. Well, yes. Action proceedings. That's for tomorrow. So it's the remainder of jurisdiction, the forms of proceedings, and then action proceedings. We will be dealing with all of those tomorrow. Any questions before I bid you all farewell? Romeo? Okay, sorry, let me go up. Mariska? Along with the announcement of this link, there's an attachment of what the topics will be for each day. Thank you, Mariska. Romeo, when a high court issued an instruction note, is this applicable on all lower courts? No, Romeo, it's not. Only judgments of the high court are applicable to lower courts, not instruction notes. Instruction notes are in respect of high courts only, by the high court. The Supreme Court will issue instructions in respect of in respect of the Supreme Court only, and not to the high courts, and similarly so with the Constitutional Court. So each unto its own, and each one instructs itself, as well as practice notes. Practice notes in the High Court apply to the High Court only. The Magistrates Court will have their own practice notes, and they will apply to them only. So we have 3 more minutes left if you want to ask questions. Yes.
Thank you. My name is Jacob.
Hi, Jacob.
Yeah, say if I'm involved in an accident, say in Durban, and I'm staying in Pretoria, can I move the jurisdiction now from that point to the place where my homes are?
Not you as the plaintiff. You must follow the defendant or the place where the accident took place. It's where the defendant resides or carries on business, or where the accident took place.
Oh, yes. All right.
But it can never be for your convenience, Jacob. It's never the plaintiff's convenience. It's where the defendant resides or carries on business, or where the cause of action took place, the accident.
Point taken. Thank you.
My pleasure, sir.
Okay, can I ask a question? Following up on what Jacob is saying. So that would mean if he wants to lodge a claim with the road accident fund, his attorney in Gauteng will have to brief an attorney in KZN, because that's where, or am I lost?
Yes, you'll have to instruct a correspondent attorney in KZN if that's where the cause of action arose.
Hey, okay.
Yeah, boy.
Thanks.
Pleasure. Anyone else? 1 more minute. 1 more question.
Hello?
Yes?
Advocate.
Yes, Jeffrey.
Yeah, just on the on the question that was asked now regarding the road accident fund. I just want to know, since the fund's head offices are in Pretoria, say the accident happens in KZN, can you then now make proceedings in a Pretoria court?
Is it the? Are you referring to the magistrates court?
Accident in KZN.
Magistrates court.
Yeah, let's just say it's covering. Yeah.
Yes. If it is the magistrates court, yes, you may institute proceedings in Pretoria.
And if it's High Court?
Yes, you may too.
Okay.
But remember, we're not dealing with High Court here. We're dealing with magistrates court. I made that clear from the beginning.
No, I just wanted to know whether do you have to get a correspondent in KZN, or you can also bring it to Pretoria if you are based in Pretoria?
No, you can bring it to Pretoria.
Okay.
But if you are going to institute proceedings in KZN, you will have to. If you decide to institute proceedings in KZN, you will have to instruct a correspondent attorney to act on your behalf.
Noted. That I understand.
That was the gist of the question that was asked.
No, I just wanted a follow up as far as the respondents please, because the
defendant, sir.
Yeah, the defendant.
You are quite correct. If your question is, may you follow the defendant as the road accident fund in Pretoria? Yes, you may.
That was the question. That was the question.
Yes, you may, sir.
Okay, thank you.
Thank you. We are done now. It is 32. It is 28 minutes to 9. 2 minutes over our scheduled time. Jeffrey?
Yes, sir. I just wanted to find out practically. So, how do you establish a jurisdiction of illegal immigrant?
Huh? Is that anything to do with magistrates court? And be more practical, please.
Yes, this person. I have a case. I have a matter with this person, but in terms of status, he doesn't have a fixed address. I'm just giving an example of an illegal immigrant. How will I establish his jurisdiction? Because it's not having a fixed address. One day is on this address, second day is maybe in Mpumalanga. Yeah, that's what I wanted to ask.
No, sir, you are going to have problems with pursuing that person, because that person, you need to follow that person to wherever they are, and if you can't find them, then you have problems. You are going to have problems establishing jurisdiction there. Not because he's an illegal immigrant, but because he doesn't have an address at which you may serve him with process and to establish jurisdiction. It's a different story if that person was the plaintiff and that person wanted to establish jurisdiction, because it will be easy. Then that person will have to disclose their address. But if you are looking for that person as a defendant or a respondent in proceedings, you are going to have problems because you don't know where the person resides or carries on business. The fact that it's an illegal immigrant is neither here nor there. The fact that he's in South Africa, if you can establish an address for him or her, then you can establish jurisdiction. It's not a requirement in terms of our constitution that anybody has to be a legal immigrant. Even illegal immigrants have rights.
I'm clear. Thank you, sir.
Are you clear?
Yeah.
All right, then. On that note, everybody, thank you for your time and your attention here this evening. I've indicated to you what you need to read for tomorrow. And thank you for your participation as well. For all the relevant questions. Take note, relevant questions. Let's continue in the same spirit tomorrow evening, and enjoy your evening tonight and tomorrow. Good night.
Good night.